evening and welcome. Welcome to the Cook County Bar Association's Live on CAN TV. Today, our host will be Attorney Lewis Powell. I will be your guest, and our topic will be child support. We take this opportunity every Tuesday at 6 p.m. to discuss legal topics of import to the Chicagoland community. Now, I am an attorney, and Attorney Lewis Powell is an attorney, but we do not represent your interests. So, if you are ever in need of attorney, or if the topic that we're discussing on tonight's show or any of the future shows do not address your issue, please feel free to go to the Cook County Bar Association's website, and you can find it at cookcountybar.org. As you can see on your screen, you click on, that's cookcountybar.org, lawyer referral, click on that. And as you can see, there's a list of attorneys who are members of the Cook County Bar Association and who are licensed to practice law in the state of Illinois and are in good standing with the bar. And their topic areas, their contact numbers, and email addresses, so that you can contact them and ask them specifically about your issue and get some competent and well-needed advice. You may or may not know that the Cook County Bar Association is the oldest association of African American lawyers and judges in the United States. And we are proud to provide you with information regarding legal issues that hit the news, the headlines that people are talking about, and legal issues that we know the community is typically concerned with. And one of those issues is child support. And so, to begin, I'd like to give you just a few statistics. In the state of Illinois, the law pertaining to child support was enacted most recently in 1984. It has recently been amended, and the new act will go into effect July 1st of this year. And from the time that the law was enacted in 1984, the numbers of unmarried having children, it was 44,796 unmarried women having children in the state of Illinois in 1984. The total number of live births were out, and I'll put the statistics right here so you can see it. The total number of live births in the state of Illinois, as I said, in 1984, as you can see, was 179,216. That made up 25% of the unmarried women having live children, made up 25% of the total number of live births in the state of Illinois. Now, as of 2010, the total number of live births is 164,998, and the percentage of that total that represents children to unmarried women is 40%, and that is 66,787. So as you can see, we have increased from 1984, when the law was originally passed, enacted, and into 2010. Okay, our host is joined us, Attorney Lewis Powell. Just to let you know, I've done the introductions and our little disclaimer. And I just wanted to give some statistics to the viewing audience to let them know how much has changed in the state of Illinois with regards to the number of children being born in live births, and that the children that are born to unmarried women indicates the need for child support laws, and that's our topic for today.
Absolutely. I apologize. My helicopter's run a little bit late.
Well, we're glad to have you here.
But in any event, Mecca, this is a very important topic. We have a lot of folks out there, men especially, that are delinquent in their responsibility
Okay.
and we really want to just put people on point. Let's start off with a couple of questions. If that's
Okay.
okay with you. And we know that I think you touched upon the law has changed in Illinois. How has it really changed in terms of child support?
Well, just so that we can get a clear background with regards to child support, that when we talk about changes in the law, the first thing that's changed is the terminology. And so we've had a show in the past that described some of the terms that have changed, but I want to get into a little more detail regarding that so that we can be clear what we're talking about. So, for example, visitation is now called parenting time. Visitation order is considered a parenting plan. Custody is no longer used. The term is allocation of parental responsibility.
Okay.
Removal, which means to change the child's permanent place of residence, is now considered relocation. So the terms, and these are just a few examples of the changing in the terms. And as you can see, the idea is not to make it so judgmental or order or legalistic, and really talk in terms of actually what the parents are involved in. Parenting time, a parenting plan, allocation of parenting responsibility versus a custody or control type situation. And so the language with regards to the parents have changed. And as I explained to the viewing audience, the Parenting Act of 1984 is the previous law. It is called the Parenting Act of 2015, which is now the new law, and as I stated earlier, it will go into effect July 1st.
Well, Counsel, let me ask you this. How about in terms of expenses? Has that changed in terms of what is fair play for child support?
Child support, for the most part, still remains to be divided into costs concerning the necessities first. Those are the basic expenses that are considered that need to be covered when you're talking about child support. So that's the shelter of the child, costs associated with sheltering the child, costs associated with food and clothing. We do have a caller.
Caller, are you there? Caller, are you
Hi
there?
there. Hi there, sorry. I'm calling, you may have touched on this, but I just started tuning into the program. My sister has a situation with her ex. They're going through the spousal support or child support, I'm sorry, and it's been about a year now since she filed.
Okay.
And he's saying that he makes $30,000, and he's a realtor. And she knows that he doesn't because she can see all of his sales in the MLS. So how do you get around that? Like, I thought he should use his taxes, but I mean, it looks like the judges might be believing what he says.
Okay, well, legally under the old law and under the new law, they do look at your tax returns. I mean, that's something that both parties are supposed to be able to turn over to each other under the disclosure requirements in the Illinois law. So it is tax recurrence. The thing is, it's not just that. In addition to, there is, especially when you use the tax returns, there's deductions. So it's not just the gross income that's taken into consideration, it's also the deductions that someone can claim. And a realtor can claim a lot of deductions, can't they?
Absolutely, because most realtors are self-employed, most realtors are independent contractors, so there's a number of things they can write off in terms of expenses. And it's kind of hard, just because you're seeing on MLS, you're seeing sales.
Right,
I'm
that's not
sure.
right.
I'm not quite sure that you can tell what the commission is unless you're a licensed realtor. If you're a licensed realtor, you have access to MLS, and you can determine what the percentage of the sale is in terms of what the commission is. But for the average citizen, I'm not quite sure. You can see the sales being made, but that does not necessarily mean what the net is.
Well, fortunately, caller, we have Attorney Powell, who has a background in real estate, so you're really getting the detailed, nitty-gritty details with regards to that question. Yes, so under the law, the previous law and the current law, what you call the net income is used to calculate the child support. And so the court could take into consideration a variety of things, especially with someone that's a realtor, and advertising costs, expenses that they have expended. Travel is the gas mileage that is expended to show properties and basically transport potential buyers of property around. So it wouldn't just be just the gross that the court would look at. So that may explain why the 30,000 is what the person is claiming. So to getting back to
Counsel, I have a question for
Okay.
you. We've done a lot of publicity here lately in terms of maybe who is eligible to pay child support. When I'm making reference to like celebrities, Halle Berry. I'm trying to think of the young lady that used to be on the Tom Joyner morning show, which actually got canceled in Chicago, which is another topic. But in any event, she jokes all the time that her husband took her to court, and it was determined that she would pay child support. Now, what are the rules, the basic rules in terms of who pays child support?
I think in the past, child support really was something that the male versus the female was expected to pay, because more men were the ones that were out in the workforce, and women were more stay at home when they're talking about children, whether they were married or not. Today, it's both. Women and men are working in large numbers, and there are a number of women that are making more than maybe the particular person that they have chosen to have children with. So to the extent under the old law, it really was focused on who was the custodial parent, and that was the starting point. And the calculation was based on the non-custodial parent's income. And so that's how it was calculated. And in the past, traditionally, the woman was the mother was the custodial parent, and then the father was the non-custodial parent. Now we have situations in the state of Illinois where we not only have men and women being the ones being obligated to pay child support to the father or the husband, the former husband. We also have, because child support really is only something that can be imposed pursuant to a petition for divorce, and then also for unmarried parents. Now, there are situations in which married individuals can request child support, and that's really in kind of more dire situations. And I would advise anyone listening and considering that to contact an attorney to get more details, because that does tend to be more fact specific. So it's not that married people cannot, a person who is actually married at the time cannot go to the court and request child support and be given child support. Under the old law, that's definitely what has occurred. But now that Illinois has authorized marriage between same-sex couples, you're also going to have, women who have adopted, and men who have adopted children. They all are also going to be. There has to be a determination of who is responsible to pay child support. Now, again, under the old law, it was for those whoever was the non-custodial parent, that was the one that was paying. Under the new law, they are looking at whether or not the person is considered the obligee or the obliger. The obliger is the one that is looked toward to pay. However, the calculation for child support does take into consideration the income of the parent who is staying at home, and
How is child support calculated?
It's very complex now. It's a very complex calculation.
Let me ask you this, because this is not my area, this is your area. I do know this. There's only so much you can get. Is that true?
Right.
All right. I do know this. There's a problem which is kind of, duplicated with what's happening in society today, where you have a gentleman who may have 3 or 4 kids out there.
Right.
Now, is there a formula when a person has, multiple partners, and different children by different women? Is there a formula in terms of what his obligations would be?
Well, now that's a good question, and that is one of the prime differences between the old law and the new law. Under the old law, it was a basic rule that first in time, first in right, and whoever out of the multiple parents that one guy has fathered with multiple women, the women, the mothers, the first mother to go to court to request child support, got the order, and all of that child's financial considerations were taken into account. And then any subsequent orders would not require a reassessment of that first one. The first one, the first child or group of children that filed for child support, that order would stand. And if there's any money left over, then that could be distributed to the other children. Now, under the new law, that is no longer the case. It is more flexible, and the needs of all of the children are taken into consideration. Now, getting to your first question is what factors are considered. The income of both parents are considered, or multiple parents in that situation. Then the amount of time spent with each parent is factored into this calculation. And then the court has some discretion to deviate where, other circumstances pertaining to maybe there is a medical condition that it may be expensive and requires additional treatments or monies to go toward that. So it factors in a lot of things that weren't factored in before. Before, it was really a statutorily defined straight percentage of the non-custodial parent's income, and now both parents' income is factored in. They look at the net, deducting all of the requirements from the law, the tax law, the taxes and the deductions, factoring those in. And then they also look at how much time the child is spending with one parent or the other, and that's factored into the calculation. And like I said, these extra expenses are then added into the calculation. But the amount of the person's income is the starting point for both. They put both of the people's income together, and then they get a grand total, and then they're going to, after all of those factors are put in there, they take a percentage for both parties. And so the father or the non-custodial parent could foreseeably pay more under the new statute than under the old statute.
So again, we want to make it plain for our audience. I think the bottom line of it is you pay according to how much you make in terms of your net. And I think the old law was the non-custodial parent conceivably, theoretically, would pay more. But I believe what you're saying under new rules and regulations, both parties are taking account in terms of their finances, in terms of expenses, also in terms of what the net is. So it's quite possible it could be equal participation in terms of child support. Well, another question.
Oh, and just to kind of bring home the disparity, for example, in the federal poverty level for a single person is now $12,000 a year, 75%, which is $9,045 or $753 a month. Under the new law, a dad's income where he's bringing in is less than $750 a month. They could order him to pay at the minimum $400. That's a huge portion. So it really looks at, and again, in that sense, the theory behind is called an income sharing model that is being used now, and it's replacing those statutory fixed amounts. The thinking is we want to assess to both parents the amount of money that the child would be given if, or receive from both parents, if they were in an intact family or one unit.
Absolutely.
So in that respect, $400 doesn't seem like a lot for one child, but
it's not much. Council, we have about 5 minutes. Now, we want to get some key points in if we can. Audience, again, we're asking you to please call in, get the free information. That number is 312-738-1060.
One thing I do want to stress to people that are considering filing for child support, it is very important and that both parties really seriously consider doing some sort of mediation. The one thing that is definite, where the this new calculation model is not tested here in the state of Illinois, so it's not really clear how much one person is going to have to pay versus the other. However, this is going to increase the litigation costs. There is now more room for arguing about the child support, whereas before it was pretty much set in stone before you even walked into the courtroom. 20% for one child, 28% for two, so you kind of had some idea. This is not going to be the case. As the one caller stated, the mother is thinking it's supposed to be more than that because she's looking at the sales records of her spouse, and you haven't factored in those exceptions. So it's much more room now to litigate, and that's going to be very expensive. And for families that are already in a tight financial situation, especially with the uncertainty with our Health Care Act for citizens all across this country, you really need to do what's in the best interest of those children and really just look at your finances and for what they are, be honest about them, and allow both parties to really contribute what they can and do what they can to provide the children everything that they need.
Counsel, I'm going to ask you in a layman's view. The reason I'm going to say layman's is because this is not my area. So we want to just make it plain. I think what you're saying right now, that with the new rules, it really opens it up for more litigation.
It opens it up for a lot of litigation.
Which in my mind is unfortunate. Again, it's not my area. I do know with divorce, I do know with child support, really the problem is that a lot of people are fighting and really running up extraordinary attorney fees, when if they could possibly resolve it, it'd be so much better. You were touched early on mediation, and I think you're encouraging our audience. I hope our audience is paying attention. It's far better if you go to some type of mediation, try to work it out, and then that way, again, the theory is what's best for the children.
Right.
And it makes no sense just to be constantly arguing over something when the bottom line of it is both of you are responsible for your children.
Right. And to the extent that both people can be more reasonable and just cut their losses and really try to do what's in the best interest of these kids, then you will have more room. If this person gets in hard times, you can make allowances because they were willing to do what they could on the front end. You see what I'm saying? And because these things will always need to be modified and changed, you just don't know what's going to happen in the future with, like I said, all of these expenses, health care, and then you don't know what the child's needs are going to be. So it's better to really think more long term and not be so hesitant to really put money out front for the child so that both parties can take each other seriously and respect the kind of sacrifice they're making to do for the children.
Counsel, we got about a minute. If you can, quick tips in terms of child support.
Be honest with yourself of what your expenses are. Be honest with yourself about what the other parents' expenses are, and really look at what the child needs and what other resources you have for income. Grandparents are good resources to assist with children. Other family members are really good resources, and recognize the loss that can occur from these additional resources when both parties are fighting. So that's what I would encourage people to do. And please also contact, like I said, the Cook County Bar Association with any further questions.
God bless you. We'll be back the same time, same station next week. God bless you.